welcome everyone. Good morning, good evening, good afternoon, and for our speakers, good night shortly. We're really thrilled about this discussion and excited to have you join us. This is our webinar on compensation under investment treaties, a Pareto-Improving proposal. My name is Lisa Johnson. I'm with the Columbia Center on Sustainable Investment. I'm going to be behind the scenes as I hand everyone over to our panelists and our moderator, David Gaukroger. But thanks again for joining us, and we will go ahead and get started. Thanks a lot.
Great. Well, greetings to everyone. I'm David Gaukroger from the Investment Division at the OECD, and I'm also pleased to welcome you to this event on damages in international investment law. ISDS has the highest average damages claims and the highest average damages awards of any dispute resolution system in the world. Not surprisingly, damages issues have become a major part of ISDS cases. Engaging damages experts is now routine in ISDS, increasingly at the outset of a case. Specialized firms now provide ISDS damages expertise. Essentially, all of these claims and awards are against governments and raise issues of public interest. Investors can have very large amounts of money and assets at stake. So close scrutiny of the rules and interpretations that are given rise to current ISD outcomes is important. Prominence of damages in ISDS also contrasts with domestic public law. Our comparative work at the OECD has shown that most ISDS-type claims would give rise only to non-pecuniary remedies under domestic law in advanced economies. Similarly, WTO remedies do not involve damages. So it's not surprising that damages and compensation in ISDS are topics of great interest and ones where there is interest in reform in some quarters. We're very fortunate to have an opportunity to learn about and discuss interesting new proposals in this area, and to have three distinguished speakers, Emma Esbit, KK Mashigo, and Jeffrey Sachs. Their biographical information is available on the website for this event, so given limited time, I would refer you to that. Emma has co-authored the papers that are at the center of today's discussion. The analysis develops rules under a particular constraint to achieve a particular goal. The goal they set out is to ensure that only investments that benefit the host state generate compensation. The home state is also nominally part of the analysis, but the focus is on the host state and the regulated entity. Many questions arise. Is that the right goal? It would seem on its face like a goal that many governments would be interested in achieving. Do the proposals achieve the goal? What's the impact on treaty-covered investors, other investors, and investment? Do the authors generate workable rules? And many more. As I understand them, the proposals don't address the full scope of issues addressed by investment treaties today. Questions of discrimination, due process, market access are left aside. But the issue that is addressed, non-discriminatory regulatory change, is one of the most controversial aspects of ISDS. So it's a vital debate. We will not answer all of the questions today, but questions and comments are very welcome. We should have time for some later in the hour. Please use the Q&A function rather than the chat for your questions. And with that, I would turn it over to Emma.
Thank you very much, David, for the introduction, and hello everyone, and thank you for joining whenever and wherever you are in the world today. I'd like to offer my special thanks to the Columbia Center for Sustainable Investment, to Lisa, KK, Jeffrey, and David for their time and engagement today. I'd also like to begin by acknowledging the Ngunnawal people, the traditional owners of the land on which I live and work, and to pay my respects to their elders past, present, and emerging. The work I will be discussing today, or we will be discussing today, is the product of a very long-running collaboration with my brilliant co-author, Jonathan Bonniccia, who is thankfully also online today, and will be there to field questions of a lawyerly nature. I'll go ahead and share my screen now, and hopefully that works. So you can all see the screen, I hope. Some of you, those of you who do know me in the audience may actually know me as an empirical researcher who analyses data to interrogate the drivers and benefits, or possibly lack thereof, of participation in investment treaties. Today, I'm here to tell you about how we combine economic theory rather than empirics with a deep understanding of investment treaty disputes and institutions to try to find a way of separating the baby from the bathwater when it comes to investment treaties and damages. So what are investment treaties? I'm assuming most of the audience know pretty well what they are, but very briefly, they are legal instruments with an economic objective. So what do economists then, given these have an economic objective ostensibly, see as the problem which investment treaties are trying to solve? Principally, governments may find that they are in need of a commitment device because their optimal policy toward an investment is what we economists call dynamically or time inconsistent, or at least it may be. Prior to an investment, the host may have an incentive to offer good conditions and promise not to interfere with an investment. However, once the investment has been sunk, it might be tempting for the host to opportunistically try to extract greater benefits for itself from an investment at the expense of the investor. This is an example of the hold-up problem, and it leads, when it happens, to underinvestment, and importantly, it's a problem which harms both the investor and the host. This problem can also leave some hosts forced to pay higher risk premia to obtain the investment they need in things like transport, water, and importantly, energy infrastructure. Current compensation rules under investment treaties try to solve this problem by making hosts compensate investors for any losses incurred as a result of their actions. The central problem with current compensation rules, as we see it, is that hosts can be severely punished for responding to new information. Additionally, current compensation norms, both in breadth and magnitude, are well in excess of what is required to solve the underinvestment arising from host potential problems of time inconsistency. Of particular concern, we know that good policy is actually responsive to new information. The COVID pandemic gripping the world today is an excellent example of the fact that prior to investments taking place, there are always unknown unknowns that the host will need to respond to once they are revealed. Another relevant example is green industrial policy, which is by far our best hope of avoiding catastrophic climate change. Green industrial policy, like all industrial policy, requires policy experimentation, learning, and updating if it is to be successful. By punishing governments for their responses to new information, current rules can leave host countries, indeed the entire world if you think about something like climate change or even COVID, worse off by forcing hosts to either forgo public good actions or pay hefty compensation for taking them. So what is the solution to these twin problems? Many lawyers that I've spoken to say it's impossible to disentangle the hold-up and new information problems because arbitrators can't tell whether the new information was just an excuse that was used by the government to take some sort of expropriatory action. That's all very well, but the beauty is that using economic theory, we've designed a compensation rule which can actually distinguish the two without any arbiter or judge ever needing to form an opinion about what the host's true motives were. The principal way in which we do this is by changing the counterfactual situation against which the actual outcome is compared for the purposes of calculating compensation. The counterfactual currently used in investment treaties is a situation that would have been had the host not taken the offending action or change. The counterfactual we use is the situation in which the new policy, action, or approach of the host had actually been in place before the investment decision was made. Our second innovation is that we ensure that compensation paid is the minimum required to solve the underinvestment problem. We do this by making compensation the lesser of either the host's gain or the investor's loss compared to our counterfactual situation. When the compensation is equal to the host's gain from acting opportunistically, any incentive to act opportunistically is removed, so the host's commitment problem is thereby solved. Where the investor's loss is less than the host's gain, and our rule would suggest in that case that compensation equals the investor's loss, the host may still act opportunistically, but compensation of the investor's loss is sufficient to ensure this possibility does not have an investment depressing effect. Either way, our rule solves the problem of underinvestment due to opportunism, and it ensures that hosts can never opportunistically gain at an investor's expense. Our proposed rule then is that a state should only have to compensate the investor if it breaches or modifies the domestic legal regime governing the investment, and that compensation in this case should be the lesser of the investor's loss and the host's gain from the host not having had the new legal regime in place at the time the investment was made. In our Journal of International Economic Law paper, well, actually largely in the online appendix to that paper, we proved the implications of our rule for things like the level of investment, the welfare of the host, the welfare of investor, and the global welfare. We also compare these outcomes for our rule to those for two stylized interpretations of the current regime, namely a strict rule awarding investors full loss in every case, and what is essentially the Micheli-Sergison rule. So I'm guessing that a lot of people in the audience today are interested in what this rule would look like in practice. Economic theory is not necessarily the primary interest of everyone. So to start with, I would say that if you're very interested in particularly the legal applications as well as examples of how our rule would work, please take the time to read the paper that's been lead authored by my co-author Jonathan Bonniccia in the Michigan Journal of International Law. But I have time for a couple of brief examples here today. One very, very controversial example is the non-issuance of mining licenses. Things like the infamous Tethian copper versus Pakistan case, which we know led to almost $6 billion in compensation being awarded. We know how the current rules work. They very often have this sort of outcome where the very large compensations are awarded on the basis of the expected profit of the mine if the mine had been approved and allowed to run its full lifetime. For our rule, the counterfactual in this situation is one in which the investor never invested, as opposed to one in which the mine got to run its full life. So given this, the investor loss is actually the irrecoverable project costs to date. Now, importantly, this will need to include all the costs of finding a successful site to mine in the first place. Now, our rule may say that the investor loss is what gets compensated, or it might say that it's the host gain. And so we need to compare the two to see which is the lesser. In our rule, the host gain, once again, compared to the case where the investor didn't invest, because if the investor knew that the mine was ultimately going to be shut down, it wouldn't have invested, could be one of two things. In the situations, and we've seen quite a few cases of this sort of situation, where the host actually doesn't issue the license, but also doesn't let anyone else develop the mine site, for example, for environmental or social reasons. In this case, the host has actually gained nothing by letting the firm come in, do its exploration and discover where the mineral deposits are, because then it's not using that information because of the environmental or social concerns. So in these sort of cases, our rule would suggest that there's no compensation due. In a case where it's evident to the arbitral panel that the host country or even a domestic constituent that the host passes on to actually takes the information that, and for example, the infrastructure that the investor provided about this potential mine site and use it then to undertake mining themselves, then there obviously has been a gain to the host. And this starts to look much more like what we think of as a traditional expropriation case. And in this case, our rule will also award compensation. Once again, not for the full value of what the mines would have been, but for the value of what that information and what that infrastructure was worth. The next example I'd like to talk to is one very dear to our hearts here in Australia, and that is tobacco plain packaging legislation. And as we all know, the Philip Morris versus Australia case, which of course was actually dismissed on jurisdictional grounds, so we don't know what the tribunal would have found had Philip Morris had a legitimate treaty on which they could base their claim. So this in some ways is an example of a case where the changes brought about by the government reduced the profitability of an investment, but did not reduce it all the way to zero. Philip Morris are still in Australia, still operating, still making profit in Australia. So if you think about the counterfactual, then it's not a case where the investor wouldn't have invested, because clearly it's still a profitable investment. Rather, the counterfactual here is that they invested and all along had to face these plain packaging issues, which according to them have reduced their profit. So relative to that counterfactual, Philip Morris was actually better off that Australia had not had the plain packaging rule in place at the time. Therefore, there's been no investor loss for the purposes of our compensation rule. So that alone says that there will be no compensation required under our rule. In this particular case, it would also be true that the host, who clearly values the health of their people more than any taxes or anything that they've recovered extra from having this extra operation in the intervening years, has not gained anything either by delaying the introduction. So also in terms of the host gain, the answer would be zero compensation from our rule in this case. The final example I want to share today is very topical globally in the context of the massive need for investments in renewable energy and in low emissions technologies. All of this prompted by huge amounts of green industrial policy, which we know requires policy learning. And the Spanish government has really borne the brunt of these sort of case, where the policy learning, also indeed, you know, the problems that were requiring subsidy in the first place get resolved as technology matures, and therefore the policy to support them needs to be wound back. And this is an example where, once again, in this case, our rule would actually say no compensation was required for the Spanish solar cases, because the investments were still, importantly, still profitable for an efficient operator of a solar farm. So I think I'm running short on time, so I'll just conclude. Our compensation rule is really designed to ensure that investment treaties benefit both host as well as source countries. And of course, all countries are a bit of both. So if you're benefiting both, you're benefiting everyone in between. Our rule also prevents, it does this by targeting the compensation and preventing the threat of opportunism from constraining investment. Our rule, unlike the current system, is compatible with responsive regulation and policy learning. And something that I will leave the lawyers to explain later is that it also can be implemented as a change in the way that damages are calculated under existing investment treaties. So thank you very much, and I look forward to the discussion and questions.
Thank you very much, Emma, for that very cogent and concise presentation of the immense amount of work that I know you and Jonathan have put into this. One thing that struck me, you rely on you discuss some of the papers arising out of debates in the United States over regulatory takings, and yet your analysis in the paper focuses exclusively on investment treaties. One theme of our work at the OECD has been to kind of compare investment treaties to domestic law addressing the same issues. And I think the allocation of losses from regulatory change is a ubiquitous issue in domestic law as well. So one query I have for you, what you can respond to later if you have time, is whether that you consider that your analysis would also be relevant for domestic law rules and on the same issues. And this may be of interest in particular to KK Mashigo, who is our first commentator from South Africa. And South Africa has largely recentered its applicable law on some of these issues in its domestic law. So I think the question may be of interest there. So I turn now to KK for some comments on Emma's presentation, please.
Good morning, afternoon, and evening to all. And thank you, CCSI, for hosting this event. Thank you, David and Emma, for the introduction and the presentation. I believe this proposal is timely and welcome, given the current discontent with the ISDS system and the fact that one of the issues of concern has been that of compensation and damages. It offers a good starting point to encourage thinking around the issue of compensation and damages and to engage on alternative approaches. I think the legal principles governing compensation in investment treaty arbitration and the way tribunals have interpreted and applied these principles have implications for states, investors, and other participants in the investment treaty regime. Now, to pick up on the point that David raised in comment to Emma's presentation, I think the point that David raised speaks to the potential scope of the proposal, which seems to focus on ISDS only. I think this is an interesting point, given that many countries have or are reconsidering their approach to investment treaties and have moved away from ISDS and require exhaustion of domestic remedies. For instance, South Africa is one of those countries, and I think Brazil and India. So the question is, would the proposal therefore not be relevant in all instances where compensation or damages are to be determined, be it under ISDS or domestic courts? Personally, I think it would be relevant in light of the fact that the hope is for the scope of damages to be restrictively interpreted so as not to overburden countries, maintain uniformity and consistency, and enable the promotion of economic cooperation and development between countries. But I'd also be interested in hearing Emma's and Jonathan's comment on this point. Now, moving on, the proposal highlights a series of pertinent items in terms of, firstly, how arbitral tribunals approach the notion of compensation and what kind of reasoning they should develop to calculate compensation damages if investment agreements are to be mutually beneficial, and in what circumstances host states should pay compensation for interference and how much compensation should be required. More specifically, the proposal challenges the key ideas on which the current approach to damages or quantum is based. The general principle underlying compensatory damages is largely that damages are awarded to put the innocent party in the position it would have been had the harm not occurred. However, this is not so for compensation paid out in investment cases. In investment cases, the actual awards of compensation damages are driven by the facts of each case and the balancing act performed by the tribunals. The proposal further seeks to critically rethink the key issue of how compensation and damages are and should be calculated in the context of investor-state arbitration. It highlights that investment treaties should be designed to ensure that there are benefits for each state party and that no state party is left worse off. Investment treaties should also not unduly constrain states' regulatory space, as this can leave host states worse off. It also distinguishes between loss arising from regulatory change, which is a risk that investors should be required to bear, and the seizure of investor assets, which is compensable. In addition, the proposal highlights the need for more acceptable principles on quantum. Compensation is the lesser of the investor's loss and the host state's gain. So ideally, compensation in the proposal is capped. For the investor loss, it would be the amount originally invested, and for the host state, it would be the amount that it has gained. So the approach aims to ensure that no one party is left worse off than it had the new legal regime been in place from the word go. In addition, the proposal seems to remove the complexity, expense, and uncertainty associated with the evaluation of the policy justifications for state conduct, as no weight is seemingly given to arguments of public interest for purposes of justifying interference when a determination of compensation has to be made. This may reduce the time and costs of a matter. The proposal also moves away from income-based valuation to asset-based valuation. In so doing, it doesn't take into account recoverability of loss of future profits. This is of practical importance as it simplifies the quantification of compensation and limits the expansion of quantum calculations by excluding the projections of the investor's future income. Inclusion of projections of the investor's future income is what has currently facilitated the inflation of awards, leading to increasingly colossal awards against the public purse, and has justified that tribunals calculate compensation or damages in a certain way. The stakes are therefore, the stakes that are usually involved in choosing between income and cost-based methods can be very high. And then lastly, in the assessment of damages, as there is a capping of compensation, the proposed approach in all likelihood takes into account that awards can affect the capacity of countries to deliver basic public goods. However, under the current status quo, no regard is given to the effect that damages can have on the host state being able to subsequently fulfill its public policy objectives. Now, I'd also like to touch on the proposed way forward in the paper. The proposal suggests alternative treaty standards that countries should incorporate in future investment agreements. And the idea is to advance these at Untitled Working Group 3 discussions. Now, there may be some concerns from some that the proposal is a radical shift from the current practice. However, this may be the way to go, given that the current practice will not easily change course in a more appropriate direction, which would suggest the need for treaty reform. It may well be that the current arbitral compensation practice is so entrenched that only treaty reform can realistically challenge it. It's important to underscore that the tribunal's approach to compensation has immense implications for countries. Countries' concerns about the unexpected and unintended size of arbitral awards have led to the issue of compensation being included on the agenda of the Untitled Working Group 3 for ISDS reform, and to the damages being incorporated as a cross-cutting issue in Untitled deliberations. Reforming principles governing compensation is a key priority for developing countries. It's important for the concerned state, particularly developing countries, to propose and champion reform, failing which the current status quo on compensation and damages will not change. Concerns about compensation under investment treaties are not going to magically disappear. On the contrary, these problems are being significantly expanded and reinforced, partly because many of the actors of the investment treaty regime have vested interest in maintaining a system that generates large payouts of compensation. And now millions and billions of dollars are often at stake, and countries need to reflect on whether existing jurisprudence and practice on compensation is how they intended the investment treaty regime to function. And if not, then countries should prioritize compensation as an area for reform, and tribunals need to rethink calculations for damages. Now, there's two questions that I'd like to pose to Emma and Jonathan. I think one is linked to the issue of scope. What is the scope of the application of the proposal? Would this proposal be feasible in state-to-state disputes? And then secondly, we do not know what the eventual outcomes of the Untitled Working Group process will be. So if there's no multilateral instrument from the process, how else could the proposal be advanced? Thank you. Those are my comments.
Thank you very much, KCAT. I think you've really powerfully underlined the importance of these issues for governments, in particular, both the direct budgetary impacts, but also the indirect impacts on policy space, and the critical need to make sure that the incentives in those areas are good ones. One of the elements that I think is really, I won't say unique, but certainly very valuable about Emma and Jonathan's work is that it reflects joint work by an economist and a law professor. That type of collaboration is unfortunately all too rare, and as I say, it's certainly very valuable. And here today, I think KK's insights from a legal perspective will be very well complemented by Jeffrey's insights as an economist. So I would turn it over to Jeffrey now for some thoughts on the papers.
Good. Thank you very much. Happy to be here and to be listening. And I apologize that I have not read the background papers. So I just saw the PowerPoint a couple of days ago and was thinking about that and have not read the formal models, and which I look forward to doing. So please take my comments in that regard. I'm a skeptic of the entire system, which seems to me to be completely out of control. So I'm wondering whether your proposals really bring it back into control. It seems to me that this was an idea created around one theme: the opportunistic behavior towards an investor that has made sunk costs. And that regime has now expanded to include every kind of behavior imaginable that has nothing to do with opportunistic behavior or time inconsistency. So I think that a prior question for all of our consideration is whether this regime is well targeted at the opportunistic behavior that was the ostensible purpose of having ISDS. Every time that I've looked at an ISDS case, which admittedly is not as extensive as you have or as CCSI has, I've been aghast at what is ostensibly being adjudicated or arbitrated. Is it conceivably correct to think that a tobacco labeling case has anything to do with opportunistic behavior at all? Of course not. There's nothing in that case that in the slightest way resembles the model of time inconsistency. That is a public health regulation case. Almost all of the cases that I know of involve issues of environmental management, of community rights, of procedure and process. I know of very, very few takings that are along the lines of the opportunistic model that ostensibly lies at the core of this. So since you're an empirical researcher, this is the first point I would ask. If you go through 100 of these arbitrations, are there 3 that fit the model of opportunistic behavior? I doubt it. You said that you want a rule that doesn't get into motives. I think that's not a defensible position from a jurisprudential point of view. The law deals with motives constantly. And almost everything that we're seeing in ISDS is about motives. Companies, governments are saying our motive is public health. Our motive is due process. Our motive is community participation. Our motive is environmental management. That's important. And by the way, prima facie, vastly more convincing than the sometimes claim of these companies that these are just arbitrary, opportunistic takings. So I think that the huge problem in this whole area is that we have a remedy that is out of control, that had a theoretical purpose, but there's no link in practice between that theoretical insight from the 1960s economics literature and the realities of today. Governments need to regulate, they need to tax, they need to change standards. When you say they respond to new information, what you're really saying is that they're governing. It's not information so much, it's applying environmental standards, it's making an energy transition, it's protecting public health. And the audacity of investors and of these arbitrators and of UNCITRAL and of the World Bank and others to say you can't do that without compensating companies is outrageous. Of course, this is a normal area of jurisprudence within each of our countries over the last 150 years. US businesses do not have a right to sue the US government when it changes a tax law, when it imposes a new regulation, when it imposes a public health standard. Even if it puts them out of business, they don't have the right to do that. And incidentally, because it's the US government, even bilateral investment treaties are not going to protect Trans Mountain Canada, or Trans-Canada. Is that the company, the one that threw out the Keystone Pipeline today, said we abandon it? Well, they threatened to sue the US. Fat chance. I don't think that they're going to get a settlement. And by the way, the first time the US government is successfully sued under ISDS is the last day there's an ISDS process in the world. I can assure you, this is a neo-colonial system. This is not an international system. Rich countries don't get sued. Poor countries get raked over the coals. So this is a starting point. I know the Texas case, it's mind-bogglingly disgusting. The whole original, there was no mining agreement. There was no right at stake here. There were bribes by the mining companies, which is pretty typical. The ones that are suing right now are not even the original companies, because basically this was selling off a non-claim to new investors. And the idea that new investors invoke the right to mine for something that was never licensed, never approved, granted by an administrative agency that did not have the law to do so, according to the Supreme Court of the country, with evidence of corruption in the process throughout, and then a $5 billion settlement, shows a Frankenstein's monster. It doesn't show a legal process. It shows something that would come out of a horror story or a bad science fiction novel, being taken over, the world being taken over by ISDS. So this is my first point. How much of this is really about opportunistic behavior? Very, very little. That's, I think, a starting point. Second is, if it is opportunistic behavior, why do we need cash judgments? Why don't we have strict performance, non-pecuniary remedies? Okay, if there was a taking, that taking is reversed. Why are we in the compensation world at all in this story if it's behaviors that are somehow illegal, which they're not? These are regulatory changes. These are not opportunistic takings. Third, why is it under domestic law? I mean, why isn't it under domestic law? I don't understand that. Again, if you could say that the specific is that there's opportunism and only opportunism vis-a-vis foreign companies, that would be interesting. That also is not almost anywhere evident, even if it's opportunism, the idea that it's targeted at just a foreign company, pretty rare from what I've seen. Then just a question. I'm not sure whether you're your standard actually even stops the true opportunism, because it seems to me you say if you continue to operate, you haven't suffered a loss, but the opportunism could be taking a piece of your profits, your rent away through truly opportunistic behavior. You continue to operate because you have sunk costs, you're less profitable. That's a loss. So I'm not sure I understand exactly the principle. And again, I'm pretty sure that that's because I haven't read the papers. So it's an apology on my side and a question. But I'll just finish by saying that I don't think the problem in this system is the compensation rule. I think the system is irremediably broken. An idea that morphed into a monster that is out of control and that makes a lot of lawyers that live near me in Manhattan quite rich, I suppose, and the rest of us utterly befuddled. So that's my basic take, that we shouldn't think of the compensation rule being the real crux of the ISDS matter. What we should think of is the question, is opportunism the problem? How would you identify it? What are the legal standards you would apply to decide that something is opportunistic? And what are the remedies that you would apply to opportunism? So it seems to me to go back to the core of this and identify if there is a market failure or a time inconsistency problem, how would you identify it? How would you measure it? And how would you remedy it? And everything else should be stripped away from this because regulations in pursuit of public interest should have nothing to do with international rules under investment. Back to you, David.
Thank you very much, Jeffrey. I think those remarks indicate, some of the profound questioning of this system as a whole and the intensity of the challenge to its legitimacy. KK mentioned that Emma and Jonathan's proposal might be considered to be radical by some, but you've heard something more radical. So perhaps it's a moderate proposal, I don't know. Some of the themes that Jeffrey raised, the differences again in the law between advanced economies or some advanced economies and some of the outcomes in ISDS. The question of how much opportunism there is in a changed situation where we have a lot more competition for investment between governments than when the system was originally designed. Some of those change the need to address public policy issues like climate change and so forth. I'll just note in passing that at the OECD, governments in March launched a new broad reconsideration of the investment treaty regime to look at it in light of the many changed circumstances since its original design and also the many evolutions that it has undergone in treaty practice, but also in arbitral interpretation. So Jeffrey has raised many issues, as has KK, and so I'll turn it over without further delay to Emma to give us some thoughts in response to things that she's heard. Thanks.
Thank you, David, and thank you to Jeffrey and KK. Jeffrey, with all due respect, I really look forward to you reading the papers but firstly, I'd like to thank you because actually what I heard in your discussion was an impassioned call to arms for our paper to be written. We have done, I think, exactly what you're asking for. Our rule does strip away everything else except the opportunism. And this is, this is what I was saying in the presentation. Lawyers for the longest time have said you can't ever disentangle the two. This paper grew out of an argument between Jonathan and I many years ago on the point of you can't figure out what the motives are. You can't figure out what's indirect expropriation versus genuine public good. people don't have to. The maths of this rule does it for you, and it extracts the gain to the host relative to that counterfactual. And that is what gets really at this heart of the opportunism. So thank you. Yes, a lot of agreement. I would say this is not only a developing countries problem. I mean, admittedly, you know, places like Pakistan and Argentina have really copped the, you know, the hugest cases against them. But I think, you know, UNCTAD put out a year or so ago that 40% of cases were against high income countries in that year. Spain would certainly argue that they're not exactly a developing country, and they got hit as well. So yes, obviously there is US exceptionalism, and that is likely to continue. And there is, of course, another country, China, that not many investors even contemplate bringing a case against because they don't want to threaten being shut out of the market. But for the rest of the world, high and low income, you are seeing these sort of cases. And I agree, very many of them have a substantial element of, if not entirely, public good and environmental or health concerns at their centre. Yet there are some cases that, you know, if you read them, there is certainly an element of, you know, things like telecommunications companies being sold licenses for certain bandwidths and then just having the rights to use them completely taken away, and the government has made off quite happily with the payments for those licenses. So I think the other thing is that we are seeing the rise of right-wing nationalism in many countries of the world. And so while we have had a great period of liberalisation, I don't think we can assume that that's going to last forever. Finally, the reason that I actually, because people who know me would know I sounded very much like you not that long ago. These days I work on energy transition, and we know that renewable energy is all about upfront costs and has almost no running costs, right? So it is, you know, prime case for expropriation. It is also something that we need absolute, unimaginably large amounts of investment and foreign investment in the world in the next 10 years. And so we need every tool at our disposal to make that happen and make sure that it's not being hindered. So for all those reasons, I think a rule.
But Emma, just if I could ask, most of these cases are fossil fuel companies that are having their rights turned away, that we can't mine coal, that it's the opposite of what you're saying in practice.
So our rule is, I mean, yeah, I want to be careful who I talk to. It's it sounds like a major change, but I actually think if you look at the implications, it's radical. And so those fossil fuel companies, Adani in Australia, for example, you know, is a classic case of a big coal mine that may or may not get stopped on climate change grounds eventually, and Adani have threatened under our rules, they wouldn't even bring a case because the answer would be very clearly you get no compensation. And so I think it's, you know, it's maybe just the little card that you pull out of the base of the house of cards that can make, in my view, all the things that are wrong with the current system fall away very rapidly.
Thank you.
So at this stage, I would perhaps turn to one of the questions in the question and answer, which is essentially one from Justice Jose Afrier. The question really of the capacity of countries to use your rule. It's a workability question, I guess, in that sense. So that's one. Do they have the capacity to match up with the elements contained in the proposal? And then I guess on this issue of the energy transition, you see, and Jeffrey raised the issue of how much opportunism is. And I think you noted in your presentation that your rule actually does allow for some opportunism. So if you have a case of someone who invests in renewables and wins, they start generating significant extra profits. And then the government comes in and drops them down to just enough that they would have made the investment. And if the investor knows that the government has the power to do that without having to pay anything, if I understand it, would that not have some kind of deterrent effect or lack of incentive for the critical investments that we do need, as you note, in renewables? So I guess a couple of questions to you, the one on capacity, and then this issue of whether you still allow for some opportunism that perhaps at least in renewables might be of concern.
Sure, thank you. And Jonathan, let me know if you'd like to respond. Also, I'm aware that I didn't get to Kike's excellent questions, but they are actually questions that I'd rather Jonathan got onto. So yeah, that's, as you said, our aim is not to fully solve the opportunism and make sure the host never acts opportunistically. Our aim is to solve any underinvestment arising from such opportunism. And so in the Spanish solar cases, for example, the tariffs, the feed-in tariffs were dramatically reduced, but they were still calculated such that a reasonable firm would be operating at a profit. And so you might say, the host has gained, although in this case I would argue it hasn't, but in this same sort of situation where perhaps the rents are extracted and taken from the investor to the host, so long as the investor would have invested anyway, knowing that that was going to happen, then there's no loss of investment. And that's basically how our rule is designed. So to not fully solve the opportunism problem. The other question about states' capacity, and I think Jonathan could hopefully speak better to this as well, in many, many ways, as Jonathan explains in our Michigan paper, this is a much simpler system than the existing system and hopefully much more accessible. So Jonathan, would you like to jump in?
Yeah, thanks, Emma, and thank you so much to our commentators for those wonderfully engaged and generous comments. On the state capacity question, I guess there's two different ways to answer that. So one of them, which I think Emma was alluding to, is how does our rule interact with, I guess, state regulatory capacity? And I think here, because the rule is precisely targeted at underinvestment due to opportunism, that's a really important characteristic of this rule in relation to state regulatory capacity. So one thing we see at the moment, for example, is tribunals deciding these claims saying, well, did the state conduct a policy process that was sufficiently rigorous? Are the measures they adopted sufficiently effective to achieve their intended objectives? So these questions of balancing and weighing and trying to unpick policy development processes as a basis for deciding whether any compensation is due. And our rule just really cuts all that completely out of the analysis altogether. And I think that's one of the really valuable characteristics of what we're proposing. In relation to state capacity, on the question of could this rule be adopted, can it be included in investment treaties? I mean, we have some legal text in the companion paper, which we think is potentially capable of being lifted straight out and pasted into a model treaty text. But more generally, I think this is an area, and this is where I would link to sort of Keke's answer, where I think because we are really asking for such a significant conceptual reorientation in what the treaties are for, and an approach that is designed with that different or that much clearer sense of what is the actual problem here that we're trying to solve. This is something that states, I think, are better placed to pursue collectively. So ideally the UNCITRAL process at the moment, but KK's question of what opportunities are there outside the UNCITRAL process, the obvious opportunities I see there, I think are particularly in regional negotiations. So we know that there are processes underway in the African continental, is it the investment agreement? I may have the terminology wrong. There's also other regional negotiations going on. Like-minded states can get together around the side of processes like UNCITRAL and develop model text. So I would, I guess, encourage that collective thinking around reforms on compensation.
Great, thank you very much.
Can I just understand, your rule works, your rule applies whether this is a change for opportunistic reasons or for any reasons. There could be damages for any kind of regulatory change under your rule, because what you're saying is we can't distinguish what is opportunism from what is regulation. So we want a rule that will apply generally without having to understand the underlying motivations. And so I don't know the examples, I haven't thought through them, but if there's a public health rule that damages the investor, and under your formula, there are damages that are assessed, maybe you'd say it can't be, there couldn't be damages under this formula, but maybe they want to tax sumptuary behavior of some kind. So you say, oh, the government's, quote, benefiting by a certain amount, and damages are assessed, but the motivation for it has nothing to do with opportunism. You'd say, yeah, that's right, because we can't tell what the motive is. Is that, am I understanding correctly?
Yes, but I mean, so if you put on an environmental tax, for example, if it's a Berguvian tax, then it's equal to the harm, right? So then on net, there's no gain to the host. So importantly, the costs and benefits are not just not just financial for the host, not just in terms of revenue. And I think
what if you put on a tax and there's a huge social gain to the host, and you say, yeah, public health has improved, so there's a big gain, but you taxed me?
So, I mean, I think you would have to, I'm very, very confident, because I've done all the maths, that you will not capture that stuff, that the public good stuff will not get captured unless it actually, had a sort of opportunistic element to it. And so our rule will not be, it's not like all or nothing as well, right? So I think that's one of the really elegant things about the math here, is that it actually can strip out that element that was, looks like an opportunistic gain. And it might have been a coincidental opportunistic gain for the host, but it won't be the whole thing. And the really subtle change is that change of counterfactual from the, and I think that's really hard for people, if you haven't spent the many years that Jonathan and I have done thinking about this, to grasp the significance of that change in counterfactual.
Great, well, thank
Yeah,
you.
just to jump in on Emma's point on that, I think just without wanting to labor anything, I think the really key issue here is when we start talking about gains to the host state, it's really important to be clear about what the counterfactual we're talking about is for the measurement of any relevant gain. And so our counterfactual is relative to the situation that would have existed if the change in policy or the change in the law had been in place at the time the investment was made. So that's what's doing the work to exclude the sorts of cases, I think, that you might be worried about.
It seems to me, for you to be able to make this analysis, again, I apologize, I haven't read the paper or the model, but you have to have a definition of opportunistic behavior. And you have to no, I don't believe it, but I'm going to read your paper, because I can see many cases where you change a rule, you apply these calculations, except if you apply them in a way that strips out that that you have defined things precisely to take out everything except what is, quote, opportunistic. I don't see how the rule as stated makes that separation.
I'm afraid that given the limits on our time, unfortunately, because the discussion has really been engaged down some very interesting and important paths, this change of the paradigm to be thinking about things at the time of the investment under the conditions has changed is, I think, a really important part of this model, and requires a bit of intellectual gymnastics and reading the paper and applying it in some of the different fact situations and case situations that occur, as noted, I think, in ISDS, but also in domestic law. And I think how domestic courts address these is important. And increasingly, as KK noted, SSDS, state-to-state dispute settlement, as governments are increasingly interested in that area, and whether this rule could structure negotiation / dispute settlement in that broader context. But unfortunately, we have only 1 hour, so we've reached the end. I would like to thank all the speakers, the commentators, and the audience. We had some great questions that we're unfortunately unable to reach. So I would say hopefully the discussion is merely adjourned rather than terminated. I think this is a really interesting proposal. It'll be interesting for our work at the OECD. As KK and others have noted, it's definitely an interesting angle at UNCITRAL potentially. It's up to governments there to decide on the scope of their work. But with that, and I would like to thank our hosts at CCSI for the wonderful organization and help in getting the session launched. So with that, thank you, everyone, and good morning, evening, and afternoon to everyone who's joined us.
Bye-bye.
Bye-bye.
Thank you all. And
Thanks
thank
so
you
much.
everyone
Reading
for
the
listening.
paper. Thank you.
Thank
Yeah,
you.
that would be wonderful. Thank you, Jeff. Thanks for your time, everyone.